Article 14 of the Constitution in relation to rule of law. So, Article 14, as it provides equality before law and equal protection of law, so also it provides the very reasonable classification, and that very reasonable classification is regarding those scheduled caste and scheduled tribe populations, the weaker sections, and those socially, economically, and educationally backward classes, women, etc. So, the very purpose of this reasonable classification is also includes protective discrimination. So, this is a kind of reservation given to certain classes and certain weaker sections, as in case of the parliament or assemblies or all elected bodies under the constitution, so also regarding employments as provided under the constitution. So this reasonable classification of this doctrine regarding equality before law and equal protection of law do not violate the very principle of rule of law. So also the Supreme Court expresses the very doctrine of arbitrariness, and this very doctrine of arbitrariness is applicable to both the legislature and the executive, and also to all administrative authorities, not to violate the limit and not to curtail the very principle of equality as it is enshrined under Article 14. So, the very nature of laws enacted by the legislature must not be arbitrary in nature. So also the very rules, regulations, and actions of the executive and those administrative authorities must not arbitrary in nature. So the very purpose of Article 14 as regarding equality before law and equal protection of law is to bring out political, social, and economic justice as it is enshrined in the very preamble of the Constitution. So to bring justice and an egalitarian society in India. So in that regard, the very principle of rule of law is not contradicting by the provisions of Article 14 of the Constitution of India.